We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And we're back with our signature Talking Liberty segment with Liberty Nation's legal affairs editor, Uprising podcast host, general man about town, and fount of all things legal, Mr. Scott DeCasenta. Thanks for being here, Scott.
Cheers, Mark. My pleasure.
So, Scott, the big story for me this week was that Donald Trump was appearing virtually in a Manhattan courtroom to be chided, I think is the right way to say it, about what he can and can't do in the run-up to his legal case with District Attorney Alvin Bragg. What's going on?
Mark, it was billed as a chiding in advance, but I don't think that's what came off. Judge Juan Merchan had previously issued a what's called a protective order in the case regarding the evidence and how it had to be treated, namely by the defense and the defendant. So that is to say, Trump's lawyers and Trump himself. And there were some other business matters discussed at the hearing, including setting the trial date, which was set for the middle of the primaries in March of 2024. But
March 2020. Sorry, Scott, just correct me if I'm wrong, because obviously I'm not an American. Isn't that the month of Super Tuesday?
It is after Super Tuesday, but it is within the month, yes. Presumably Donald
Nothing
Trump.
political there then, because that would just be
well,
unethical.
You know, the court calendar, I'll tell you what, everything about this prosecution is political, except maybe, perhaps, the scheduling of the trial. Meaning, I imagine that, you know, the guy's got to pick, at what time would he pick that would not be seen as political? It seems like.
Next Thursday. 1 month's time, 3 months time.
You could argue
5
that at
months
least
time.
Trump gets to run through Super Tuesday in any case before he may have to suspend his campaign to stand trial if he does. But back to the protective order. The idea behind the protective order is simply that, for instance, if Mr. Trump gets some text messages or his counsel, his attorneys get text messages that are disclosed from other witnesses, and those text messages may include any number of private information that's not relevant to the charges, that Mr. Trump can't disclose, the defense attorneys can't disclose it to Mr. Trump, and Mr. Trump can't then disclose that to the world.
Let's bring this down to a layman's level. So this is just a hypothetical I'm going to give you here. Now, let's say that somebody who is providing text messages between themselves and Mr. Trump to the prosecution, this is purely hypothetical. In those text messages, that person says, you know what, I really just want to get Donald Trump to stop him running. Now, Donald Trump is now forbidden from sharing that. This is a hypothetical question, but he's now forbidden from sharing that.
No, that's not the case.
Right.
He may be forbidden from sharing it before its introduction at trial, but he's not. But it's not. The purpose of the disclosure is to get at evidence just like that. That would be relevant evidence in this trial. What would not be relevant evidence is if one of them says, I want to go to Burger King tonight for dinner because I have a coupon, and then Donald Trump tweets out that information and makes fun of the person.
Burger King loser. So sad.
Exactly, right. Burger Queen, like whatever Donald Trump might say about it, like who knows.
Sure.
But it's more about those irrelevant things or personal information about, family matters or who knows what, and there are some other things, but none of the evidence that would be disclosed to Donald Trump's defense, if it were relevant evidence in the case, that's going to be used to defend him. That's the purpose of its disclosure. It's this other stuff, that they will have access to that the instruction was on.
Now, is this standard for all cases, or is it something specific just to Donald Trump?
Gag orders, or that's funny. I actually used a term that the judge explicitly said this was not a gag order. I think maybe
because it does sound like a gag order to me. I mean, I'm not a lawyer, as everybody knows, but it sounds like a gag order. And I believe the judge says.
In fact, I'm going to quote Merchan right now.
I think I know this quote already. He says, "This is not a gag order. Donald Trump can say anything he likes outside of what I've told him he can't." Is that it?
Well,
because that sounds like a gag order.
It is, except for when you look at what is included and what he can't. And we've certainly published a link to the order itself in my written piece on this in libertynation.com. People can go read the entire order if they like. but it's about information that he's only going to get access to via the discovery process in this case. So every piece of information he had access to previous to the case, he can talk about that as much as he wants. And if it's something that he only has access to because of the discovery process in this case, then he has to filter that information through this protective order if he wants to talk about it. And for some things, he may never be able to talk about because he doesn't have the legal right to disclose it publicly because it's someone else's private information. And I think that it's, this is not a get Donald Trump order. This is an order that you might expect to see in a high profile case.
Okay, so moving on from a former president and potential future president to a current president, Mr. President Joe Biden. Now, he's embroiled in the debt ceiling talks at the moment with Speaker of the House, Kevin McCarthy, Republican from California. And there seems to be very little happening in that, with each side saying we're making progress, but no progress actually being made. It's a progressive form of progress, if you will. But one thing that has been floated by members of the Democratic Party, and Joe Biden even made mention of it while he was visiting with the G7 in Japan, is the 14th Amendment and the ability of Joe Biden to literally just unilaterally, I suppose, just pay the bills. Now, you and I have discussed this, and we did do a piece on this on the pages of libertynation.com again. But could you give us a very brief overview of why you think the 14th Amendment can't be used in these debt ceiling negotiations?
Because it has absolutely nothing to do with it. The 14th Amendment was a post-slavery amendment passed in the wake of our Civil War, and it was designed to shore up the financial situation in the United States as the winner of the war, and to reject the idea that it would be responsible for any debts incurred by the Confederacy or Confederate states. And that's all it had to do with. And what is kind of frustrating, if I had any hair in my head, which I don't presently, I might have to pull it all out, is the idea that some huge structural change can be instituted with as a result of language that no one contemplated at the time of the institution of the language. And what I mean by that is no one talked about the 14th Amendment giving the president the power of the purse, which has rested only in the Congress since the founding of the Republic. By the very structure of the Constitution, those bills have to start in Congress.
I believe it was George Mason, the founding father, who said that you can't have both the power of the sword and the purse.
He should have if he didn't.
If he didn't, he should have. I think he did.
It sounds like something that Mason would say. And so the idea that saying that the public debt shall not be questioned, which is the line in the 14th Amendment that they're trying to hang this power on, it just sounds preposterous to those of us who actually care about the very plain meaning of words and meanings. Because how else can you discuss something if later on it can be discovered that even though nobody talked about it, even though it wasn't contemplated in any way, shape, or form publicly, it meant, this whole fundamental thing that changes the entire structure of our government. It seems like an unserious way to just want to exercise power for the sake of doing so.
And just one very quick clarification on this. Joe Biden's wouldn't be using it to pay off the debts, would he? If he did try and go the 14th Amendment, it would be to borrow more money to pay off as yet unmade debts. Is that right?
Mark, it's confusing to me because the entirety of the amendment doesn't contemplate this, doesn't mention it, doesn't lay out any mechanics for it, unlike all the other things that it does when it grants power, that it states clearly how that power is to be exercised and gives grants of authority for it. With this, forgive me for this made-up idea about this, what we could shoehorn into a small void, perhaps, is a mystery to me, what the mechanics would look like.
Mr. Biden, take note, and Mr. Scott D. Cosenza, thank you ever so much.
Thank you, Mark.
And that's about all we have time for on this week's edition of Liberty Nation Radio here on the Radio America Network. I'd like to thank our guests, Tim Donner, Graham J. Noble, and Scott D. Cosenza for taking the time to join the show, and extend my thanks to you, the listeners, for joining us on the journey. One final thought to leave you with this week. When the politics starts getting crazy, I'd like us all to remember the words of the late, great David Niven, who said, "Keep the circus going inside you. Keep it going. Don't take anything too seriously. It'll all work out in the end." Those are wise words from a class act indeed. So thank you all for listening. Keep sane and keep on smiling. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides. Entertaining, informative, and just plain fun. Watch Liberty Nation's The Conservative 5. Produced by conservatives for conservatives. C5's The Left Free Zone. Hosted by Liberty Nation's Lisa K. Donner. Joined by a raucous, irreverent panel of authors. Deconstructing leftist narratives. Debating the hot topics. And remembering to laugh. Join the official conservative safe
You only
space.
did that to piss Jeff off.
Liberty Nation's The Conservative 5.